And if you have a question coming from our previous class, your time is now to ask so that we can dissect it as we go. So today is conveyancing, guys, and we have taken 4 classes previously to discuss questions to do with conveyancing. And we've discussed the first 2 parts of conveyancing. The first one being the introduction to conveyancing, and the second one being the question to do with transfer and the question to do with titles. Okay, the movement of titles and interest in land. That is what we have talked about in the previous classes. Now, in this class, before we transit into leases, remember, guys, I said that there are 3 interests in land. At the same time, there are 3 dispositions in land. So what is an interest in land? An interest in land is an interest that you can own. Whatever you own in land is an interest, okay? Now, as a conveyancing student, you need to understand, even as you speak, okay? You need to speak like a conveyancing student. So you know very well that nobody actually owns land. What you own in land is an interest in that land, and that interest can change hands. So conveyancing is all about that interest changing hands. Okay, there are 3 interests in land. There's a freehold interest, there's a leasehold interest, and then there's a charge. Okay, if you leave out the eminent domain, a principle or interest that the government has, we have 3 interests in land. Okay, now the process in which these interests move from one person to the other is what we are calling a disposition. So how do they move? The first disposition is a transfer. You can transfer it to someone else. If you have a lease, you can give it to someone. If you have a freehold, you can give it to someone. If you have a charge, you can give it to someone. That is the first movement, the first disposition in land. The second disposition is a lease. You can lease it, okay? If you have a freehold property, you can lease it to someone. If you have a lease, you can sublease it or you can lease it further to someone. At the same way, you can also list any other aspect of the property. And then lastly is a charge. You can charge an interest in land. You can charge your freehold property, you can charge your leasehold property. Are we guys together? So that is what we talked about. So in the first category of our discussion, we talked about the question to do with transfers, and we went through the question of due diligence, we went to drafting, we went to the question of completion, valuation, and payment of stamp duty, and then the question to do with registration and transfers. And in the last class, we talked about transmissions. Okay, in between, we talked about sections 24, 25, and 26, all the way to 27 of the Land Registration Act. Now, that section simply says that once somebody has been registered as the proprietor of a lease, charge, or a freehold property, then that person acquires all the rights pertinent thereto, and to the exclusion of everyone. In a layman's language, we are simply saying that if you are registered as the owner of the land, then it gives you all the rights in that land, and you can do whatever you want with that property to the exclusion of everyone. That is what you're calling. That is what we're calling the rights that come with registration. So once you get registered, guys, you are going to get few things. If it is a freehold property, you are going to get a certificate of title. If it is a leasehold property, you are going to get a certificate of lease. If it is a charge, you will get the charge. Okay? If you are registered as the chargee, you get the charge. If you are registered as the lessee, the lessee, you get the certificate of lease. And if you are registered as the as the holder of a freehold, you get a certificate of title. Okay, and that certificate of title, it is indefeasible. It means it is very strong and it is evidence enough. Okay, section 27 says that a certificate of title or a certificate of lease is a prima facie evidence of ownership. The moment you waive that title deed, then it defeats everything. Okay, it defeats everything. Are we together? However, there are exceptions. There are instances where even having a certificate of lease or having a certificate of title or really having a title deed to that property does not exclude other people. The first instance is overriding interest, easements, rights in alieno solo, restrictive covenants. Okay, those are instances where somebody can still interfere with your enjoyment of your property. Okay, so we talked about that. Now, I want to clarify a few things as we get into the discussion of leases. The first thing I want to clarify is the course, of course, the parts of a register and the parts of a title. Okay, parts of a register and the parts of a title. Okay, now remember that when you go to the land registry, why do we call it a registry? Because it contains a register. Okay, there is nothing magical, there is nothing out of this world that is there in the land registry. There's nothing. There's just a bunch of old papers and old dirty records. Okay, of course, in the past few years, the government has tried to convert all the physical registers to come, to be to something online or virtual or electronic register. But when you go to the registry, the reason why we're calling it the registry is because it contains the register. You guys went through primary schools, okay? And in those primary schools that you went to, I think I also went to those primary schools, there used to be a register of students or pupils. So if you never went to those schools, we are very sorry if you can't relate, okay? But in the schools that we went, majority of us went to, there used to be a register. So the class teacher will come with the register and he will mark every day, say who and who present or absent. Okay, so it's a register of pupils. It's the same way. Land registry contains an entire book called the Register of Properties. Are you together? If you go to the company registry, it's just a book carrying the register of companies, the companies that have been registered. So there's nothing special in the company registry. So you need to understand what is the content of a register. And number two, the contents of a title. Now remember, the title comes from the register. Hence, the parts of a title will reflect the parts of a register. So what are the things that will fall under the register? The first one is the property section. There are three sections, the property section. Are you together? So what is in the property section? What is it that is in the property section? Now the property section, just give me a minute. So the property section defines the property. Okay, the property section defines the property. It is the section that provides. It is the section that provides the different aspects or the different descriptions of the property. Where is this property? What is the registration number? The size of the property? That all of that is within the property section. So it just defines the property. Okay, it defines the property. It defines the the location of the property. It defines the mapping of the property, everything, the cadastrum, everything, the size, all that is in the property section. So that is the property section. Are you together? The property section. So the registration unit of the property, it provides also the measurement of the property. It also defines the use of the property. What is the use of the property? If the property is specifically for each and for a specific use, remember that property, each and every property will have a use. Okay, each and every property, once a property has been allocated by the government and gazetted by the government, it is allocated a specific use. Okay, so property will have uses such as industrial, commercial, residential, agricultural. Okay, so all those things, each and every property will have a use. So the use will be found under the property section. Okay, the use will be found under the property section. The cadastral plan number, the parcel number, so all that will be found under the property section. They are just things that will defines the property. They define the property, okay, and everything around the property. And then we have the proprietorship section. This is now the part that describes the ownership, the property and the proprietorship, or the ownership. You can call it the ownership section. Okay, now this is where you describe the owner of the property, their gender, their postal and physical address. This part also defines their nationality, their PIN number, and if there's any rights in alieno solo that have been registered against the property, such as cautions, restrictions, inhibitions, you'll find them under the property section. And then we have now the encumbrance section. So everything else to do with the person that owns the property. Who is this property belonging to? You will find it under the ownership or the proprietorship section. And then we have the encumbrance section. The encumbrance section, this is now the section that provides if there's any encumbrance that has been registered against the property. Okay, if there's any encumbrance that is registered against the property, you will find it. You will find it there. Okay, you will find it. You'll find it there. Are we together, guys? Are you with me?
Yes, Mwalimu.
Okay. All right. So things to do with charges. If there's any charge that is registered against the property, if it is the question to do with if it's a charge, of course, you'll have all the details, the chargee, how much, who is the lender, if it's the bank, the details of the bank, how much, how long, all that will be found under the encumbrance section. If there's any easement that is registered against the property, of course, you'll also find it. You'll also find it there, and any transaction that is on the property. Okay. So that is what we are calling, the parts of the register. Now, the same part of the register will be reflected on the title. So the parts of the title also will have all those things. The title will have the property section, the ownership section, and the encumbrance section. Okay. Tuko sawa? Okay, you guys are not saying anything as always. You are boring.
Tuko sawa kabisa.
All right, so that is the first thing that you need to understand. The next thing that also is important that I want you guys to look at under section 33 is the question of replacement of a title. If you lose a title, what is normally the procedure? That is provided well under section 33 of the the Land Registration Act. If you lose a title, you just make an application for replacement, and you get a replacement. After that, of course, there's a procedure for that. So when you look at the regulations, of course, you know what you need to do. So apply for that. Of course, you have to get a police abstract. You have to swear a statutory declaration, and then all. So that is, I want to look at section 34 of that. Section 33 of the Land Registration Act will provide you with all the information regarding the replacement of a lost title. And then lastly, or not lastly really, but I also wanted to mention the question of the torrent system of registration. Again, this is under still the question of transfers and registration of transfers. The torrent system of registration simply means or simply refers to the right of the first proprietor. That so long as somebody has been registered as the proprietor of the property in the first instance, nobody can be registered again, as the proprietor of that property. Nobody can be registered against or as the proprietor of the properties? That is the question to do with the torrent system. So it simply says that once you are registered as the property, then it is yours. And your right as the proprietor can only be altered on evidence of fraud or misrepresentation. Okay, fraud or misrepresentation. That is what the torrent system simply means, that once somebody has been registered as the proprietor of a property, then that property becomes his, and that can only be altered if there's evidence that he acquired that title fraudulently. Okay, fraudulently. So once you're registered right now as the proprietor of the property, 2 weeks later, the government or the registrar cannot register someone else. Okay, so the first one to be registered as the proprietor of the property will be the owner of the property, except where there's evidence of fraud or misrepresentation in the entire process. Okay, that is the question to do with the torrent system. So of course, it comes from the principle of indefeasibility of the title, where it is assumed that the moment you're given a title by the government, what the government is promising are two things. The government is promising you, once you get a title from the government, what is the government doing? The government is promising you that this title is legit. It is legit. It is yours. Okay? That there are no errors on the record. So that is indefeasibility, that it is a legit title that can act or that can exclude everyone. Nobody can defeat it. Is indefeasible. Okay? That is the first thing the government is guaranteeing. The second thing the government is guaranteeing by giving you a title is that in case you suffer any loss as a result of this title, then we shall reimburse you. Okay, we shall indemnify you. We shall indemnify you if you suffer any loss or any damage as a result of this title. Okay, that is the second thing that the government is guaranteeing, that if you suffer loss or damage or anything, the government will come in handy and will reimburse you. Now, related to that is the question to do with the bona fide purchaser for value without notice. Bona fide purchaser for value without notice. Now, guys, this principle of bona fide purchaser for value without notice relates to a person that buys a property in good faith, not knowing that the property is affected or is being disputed, or the property belongs to somebody else or has a problem. The title has a root cause. Okay, so if you buy a property from me without having noticed that that property, someone else also has an interest in it, then you become a bona fide purchaser for value without notice. Okay, you're a bona fide purchaser. You're an innocent purchaser for value. Why must we add value there? Because you have bought it for value. Okay. Are you guys together?
Yes. Yes.
So that is bona fide purchaser for value. Now, for you to become a bona fide purchaser for value, or for you to rely on the principle of bona fide purchaser for value, there are a few things that you must show. Okay, guys, I want you to understand where this principle is coming from. Okay, this principle is coming from this fact that somebody bought a property. Okay, somebody bought a property. After buying the property, now the real owner of the property has now come up and say, oh, I am the owner of the property. Or the government has come up and now saying this land belongs to the government, and therefore we have to take it. Okay, now will you protect this innocent purchaser? Okay, now that person that is claiming to be an innocent purchaser or a bona fide purchaser for value without notice, there must be a few things that must be certain first. First, you must be an innocent purchaser. You must have purchased the property for value. You must have paid something for it. For us to protect you under the law, you must have paid something for it. That's why we're calling it value, for value. Okay, for value. And then without notice, you must be a bona fide purchaser. 1, 2, for value. 3, without notice. So when we talk about without notice, we are simply saying that you did not have the notice that this property was being disputed. Okay, you did not have notice. It means you went through your due diligence, you conducted your due diligence very well, and the result of the due diligence, relying on it, led you to buying the property, believing that it was legit. So you are a bona fide purchaser for value without notice. And in that instance, the court or the law will protect your interest. The court or the law will protect your interest in the property. Are we together? So your interest in the property will be protected, okay? And you will not be denied the title. Why? Because you are an innocent purchaser for value without notice, okay? Without notice. That is exactly what you need to understand, okay? Now, what are some of the things that must be there for you to claim that you are an innocent purchaser or a bona fide purchaser for value without notice? Okay, the first one is that you must have a certificate of the title, or the certificate. You must have the title. You must have acquired the title. If you don't have the title, you can't claim you're an innocent purchaser. So you have the title. You acquired the title in good faith. You are just an innocent purchaser. You went and bought the property just like any other purchaser in the market. Okay. The third one, you did not have any knowledge of any fraud. You didn't have any knowledge of any fraud, that when you're buying the property, you didn't know that there's fraud that was involved in the property. Okay. For instance, if you see some property advertised along Thika Road as you go home, and you conduct a due diligence and you buy it, okay, your right will be protected as a bona fide purchaser for value without notice, if you already have the title. Okay. Number two, you paid the value in good faith, and you didn't have any knowledge. You didn't know that this was fraudulent. Okay. And then the vendor, the person that bought it, the person that sold it to you, must have also had a good title. Okay. You conducted your due diligence, and the result of the due diligence indicated that the person that bought the property had a good title. You conducted the search and you found that it had a good title. So if you bought it from me and I had a good title, then you become a bona fide purchaser. You bought it from me. When you bought it from me, I had a good title. And therefore, any person that comes to challenge that title that you have will not succeed, because in that instance, you are a bona fide purchaser without value. Okay? So you need not to have any notice of fraud. You must have acquired the title. So if you are yet to acquire the title, okay, what is this condition on you must have the title? What is this condition of you must have the title? There are instances where you've already paid the purchase price, you don't have the title, and you realize you've been conned. You are not a bona fide purchaser for value without notice. In that instance, you've just been conned. You're a victim of conmanship. In that instance, you are not a bona fide purchaser for value without notice. For you to fall under the bona fide purchaser rule, you must have acquired the title, a legit title from the registry. Number two, you must have acquired it innocently. Sometimes people buy properties fraudulently. They have an ill intention of buying the property. But in this case, for you to be covered, you must acquire the property in all good faith. Okay, in all good faith. Then another one is you must not have known that there was fraud, or you must not have been a party to that fraudulent activity. Okay. And then, of course, lastly, is that the person that sold it to you, must also have acquired a good title. So if the person that sold it to you did not have a good title, then also you don't have a good title. That is a bona fide purchaser for value without notice. So that is the rule. And then lastly is the question on evictions that I just wanted to mention. So in terms of evictions, where the government is evicting or a party is evicting someone from their land, What are some of the principles that must be followed? What are some of the principles that you must follow when you are evicting? Okay, and of course you saw this in the Mitubel case, and of course you saw it also in Sato Zayuma a case. The Mitubel and Sato Zayuma's case, you saw this aspect of eviction. So if you want to evict somebody, and also you want, as a government or as a private person, what are some of the principles that govern the question of evictions? Always remember this and always have this at the back of your mind. The first one, you must give sufficient notice. You don't just wake up one day and go out and evict people. Sufficient notice. You must give the people that are evicting sufficient notice, because if they are not having a good title on the property, then they become squatters, and therefore they don't have a right to be on that land, and therefore they should be evicted. However, if you are evicting them, you must, okay, you must adhere. You must adhere, or you must take note of the principles that are mentioned. The first one is sufficient notice. That is, you must give sufficient notice. The next one is that you must also pay keen attention to the following rights. The first one is the right to dignity. The right to dignity. The right of dignity. When you're evicting somebody, you have to adhere or respect their right to dignity. You have to evict them in a manner that respects their right to dignity. The next one is the right to life. Don't kill them when you're evicting them. The right to life. The next one is the right to security. You must provide security. Okay, so the eviction must be done in a way that protects the right to security as guaranteed in the Constitution. And then the next one is that you must give them the first priority to, number one, demolish the structures. Normally, it is advised that you don't demolish the structures. Let them, if it is a house you want to bring down, don't bring those caterpillars and bring down their houses. Let them bring the houses themselves. Bring them down themselves, or let them allow you to do that. And then you must give them the time to collect their belongings and everything that belongs to them, or salvage their properties within that compound before you can bring down their houses or whatever they have on the property. So that is the rules when it comes to eviction. Sato Zayuma and versus Kenya Railways, and also the Mitubel case. Okay, so notice, right to dignity, right to life, security, and then you also respect to the vulnerable persons. As you are evicting them, you must also pay keen attention to the interest of the vulnerable persons, including women, the elderly, and children. So they must be treated with dignity and the respect that they deserve. And then lastly is they have the right to, the first priority to participate in the demolition, and also sufficient notice to salvage the property. So don't just go and start bringing the houses down. Give them time to collect whatever they have there and then move, and then you can bring the houses down. If they decide to bring the houses down themselves, you allow them to do that. That is the question to do with evictions. Now, any question before we get into leases? Yes,
yes,
George.
I have a question.
Regina, yes, sorry.
George, I have a question just to take you back to replacement of a title. Does the same procedure apply when you want to replace a register file? Maybe, okay, not necessarily replace, but a register file is lost. Does that same procedure apply with the procedure for replacement of a title?
No, the same act provides for the reconstruction of a title, of a register.
Okay.
Yes, so there are different procedures for reconstruction. But remember, when a register is lost or destroyed, it is the registrar who is supposed to reconstruct it. So there's a procedure for doing that. When a title is lost, you apply for that. You apply for
Okay.
the replacement, and what you get is a replacement under Section 33. So reconstruction of a register is different from replacement of a title.
Okay. But okay, I just wanted to ask, where do I find that now? The procedure for reconstruction, like the application,
You're not even
the
doing.
prescribed form.
You're not even doing the bare minimum. You're not even doing the bare minimum of just doing a small search. It's all.
Okay, I'll check it out.
Have you downloaded before you come to conveyancing class, or before you start reading for conveyancing, there are a few things you must have: the Land Act, Land Registration Act, and then the legal notice, the regulations.
Yeah.
Okay, the regulations. Everything is there in the regulations. Everything. Even when you talk about the question of conversion of titles, the question to do with registration of cautions, and anything that is in conveyancing, they're under legal notice number 280. Yes, 280. Everything you find there. Everything, literally everything. Okay.
Okay.
Reconstruction, even the replacement. So what you'll find in the Act, what you're going to find in the Act is just the summary of the process. For instance, 33 talks about replacement of titles. So when you go to the regulations, you're now going to find now an entire procedure of how to replace the title. So for those two things, I've left you guys to do them. But for every other thing, we are going to discuss, even questions to do with conversion of title, conversion of land, change of user, renewal of leases, extension of leases. We will do them in class together. But remember, all these are under the Act. There are two acts. The first one is the Land Act, the Land Registration Act, and then the question to do with the legal notices. Also the 280, legal notice number 280, that is where you find all the procedures. They're just there. Okay. Even the question of reconstruction of a register, yote iko hapo. Georgina, tuko sawa?
Yes,
Sawa.
thanks.
Ukikwama uniambie. All right, let's go to Banafa.
Mine is to just take you back under bona fide purchaser for value. So after listing the preconditions, there's the last one whereby you said the vendor must have a good title. So if the vendor has a good title, what issue would arise? Because I feel like you've literally covered, you've covered every loophole. So what issue would arise if the vendor had a good title?
Maybe the person before the vendor didn't have a good title. Okay. So
Okay.
what we're simply saying is, you, the vendor, must have a good title. It means the title that you have should be one from the registry. Okay. You know, there are a lot of titles out here. So if you have a fake title, you can't pass me a fake title. That is what you need to understand. You as Banafa, if you have a fake title, you can't pass me a fake title. Okay? You can't pass me a good title. So I can only buy and become an innocent purchaser if I buy a legit one that you have. But remember, when it comes to problems with the land, they go even way, way, way deep into the roots. Okay? So somebody somewhere in let's say 2001 or 1980 will come and claim that title because there was a problem somewhere in the register along the way as we proceeded with the title. Okay? Somebody did not acquire a good title some way time back. Okay? And then that specific thing now comes to haunt you. For instance, you have seen, even with the government demolitions around Nairobi, these people got a good title. They have actual titles from the land registry. But because along the history of the title, there's a mistake somewhere. There was a mistake somewhere. Okay? And that mistake now brings this entire issue. So it doesn't have to be now. It doesn't have to be now. Maybe your great-grandfather is the one that stole this land. And because of whatever he did, he tried to regularize the title. So your grandfather had a good title, your father, and then now you. But coming back to your great grandfather, there was a problem there. Okay, so you have a good title because you bought it from a person that had a good title. And what is a good title? A good title is a title that is issued legally from the registry and reflect the register. We are not saying that a good title is a title that is free from any dispute. No, a good title is a title that is given to you by the registrar. Because you know out there people create titles. People can buy, you can create your own title, which is fake. So a title should reflect the register. So if what you have was given to you by the registry, by the land registrar, as an actual title, then it is a good title. And therefore, if a question comes up, then we shall investigate what might have gone wrong affecting this title. But you become a bona fide purchaser for value without notice. Okay? And therefore, you are protected. So we are not saying that a good title is a title that is clean from day one to last day. No, we're just saying that when I bought it from you, you actually had a good title. And what is a good title? A good title is a title that reflects the register. Okay? But if you forged a title and you sold it to me and I paid you full amount of money for that land in Karen, then I don't become a bona fide purchaser for value, because even though I've paid money, millions and millions for this land, I didn't buy a legit title, and therefore I can't be protected. So for you to be protected, you must have a good title, which you bought from a legit person. But if you don't have that, then you can't be protected. Therefore, you just become a victim of conmanship. And if you're a victim of conmanship, have the person arrested and they can refund you, or you can sue them in a civil court for breach of contract. And then they refund you back. But for a person that is a bona fide purchaser for value without notice, you will be protected, and that title is still yours. The title is still yours. Okay, the title will still be yours. However, if there's evidence that the people from the registry might have colluded to mess with this title, then they will refund you. They'll refund you your money. Okay, so remember that is the person we are calling a bona fide purchaser. So they must have bought a good title. And you know the case of Gitwanyi versus Tajmore. Okay, in that case, regarding some properties in Kileleshwa, these people bought a piece of land in Kileleshwa. They conducted a search. The search came positive. The search showed that Tajmore was the owner of the property. You know, so they bought it, and then they started constructing. Way down the line, it became an issue, and the actual owner of the property came and said, "Oh no, this title did not belong to this person that the register showed." Okay, so when this person went to court, he told the court, "Hey, I have a title. I have a search. I did a search, and I bought the property. I was even actually a title from the registry, and the certificate of official search indicated that the title belonged to this person." And the court agreed, and the court said, "You, in this instance, even though we all agree that this title does not belong to the person it was meant to be, you are a bona fide purchaser for value without notice, because all documents show that you acquired a legit title, and therefore the state compensated Gitwanyi. They were compensated for the entire damages and the entire purchase price that they paid for the property, because when you acquire a good title, you become a bona fide purchaser, and therefore your right cannot be defeated just by a interpretation of something or a problem in the title, but you must become a bona fide purchaser for value. So you must get a good title first, and then you can be protected. But if I con you, it's like buying a phone. It's like buying a phone. Okay? Or buying anything. If I con you, if I tell you, oh, I'm going to give you this, but you don't get to see that, then you can't claim. You're just a victim of a con man. You're just a victim of a con man, but you don't have. So for you to be a bona fide purchaser for value, and I'm repeating this a lot of time because I want you to understand, for you to be a bona fide purchaser for value, you must actually, the transaction must have continued normally. Okay? Uliona title, ukafanya search, ukafanya everything else, due diligence, ukanunua property. Search ilisema the vendor is the actual person. That the register ikasema the vendor is the actual owner, and you bought the property, you registered the transfer, and you're given a certificate of title or lease from the registry. That is a good title. So that title can still be challenged because the person that acquired it before might have acquired it illegally, and therefore that will not affect you because you are a bona fide purchaser for value, and most importantly, without notice of any fraudulent action. I don't know whether I've answered you, my friend.
Yes, you have. I was just trying to compare with the dinner management, whereby these guys were not compensated per se, and I was also looking at Gitwanyi's situation. So I was trying to contrast the two.
Yeah, for
But
dinner
I've
management,
understood. Thank you.
The dinner management, the court say that you have to do more. Now, the dinner management is a different case, which is, of course, is within the same line. The dinner management, now the Supreme Court now, because realizing that things have changed, it was a shift in jurisprudence where the Supreme Court said, now, listen, you guys need to stop being lazy. Okay, that is what the Supreme Court was saying. You guys stop being lazy. Fine. Traditionally, when you have a certificate of official search, that is enough. Okay, but you guys need to come out and do something more. The court should not help you for being lazy. Go out there and do something else. Look at the records, conduct your historical search, do everything. Don't just sit and be lazy. Don't just do the search and then you beat. So if there's evidence that you didn't do much, now moving forward from dinner management, now the courts are simply saying that, hey, you didn't do enough search. But that doesn't defeat your right of being an innocent purchaser. Okay, so again, that is the shift. So when it comes to due diligence, just know that there's been a shift in terms of the threshold. The threshold of due diligence imeenda juu, so that you have to do more. Okay, you have to do more. So that more is look at everything and turn every stone. Tuko sawa? Okay. So let's talk to Eric lastly, and then we can start on leases.
Yeah, thank you, Madam. On the question of the principles on eviction, could we also speak to the question of time when eviction is done? Or we can look at it to the right of dignity and security. Because sometimes we see evictions are done at night, and it's my thinking that if it's done during the day, then it covers some of the rights that we need to adhere to. Thank you.
That is all about. That falls within now dignity and everything else. You don't wake somebody when they're sleeping and then chase them. That is still dignity and security and everything else. So because of your security and dignity, we'll evict you during the day. So that is exactly the same in the same line. All right, so guys, that is that. If there's any question, please note them down as we start on leases. And leases are very interesting. Leases are very interesting, but I have a very strong feeling that we are yet to understand. We are yet to understand the question of transfers. And I'll just give you some few assignments because there are things we've done. Categories of land, we've done categories of land, right? We've talked about public land, private land, community land. Read on that. And the conversion under Section 9, how do you convert public to private? Private to community. Have that at the back of your mind. All that, again, they are in the regulations. Okay, if you guys can't find the regulations, I will get it for you and share it with you. But it's all there in the regulations. Make the regulations your friend. Okay. Also try and understand now the institution around a land. For instance, what is the work of the land registrar? What is the work of the National Land Commission? We talked about this before. When you're introducing this concept of conveyancing, and I said, look at the constitution. What is the work of the National Land Commission? What is the work of the Land Control Board? So those are the three institutions that I want you to go look at. We will still look at them together, but I want you to read on them. Okay, the land registrar, they're very simple things. Land registrar, National Land Commission, and then the question to do with the Land Control Board. Okay, and then question to do with methods of acquisition of land. This is under section 7. We talked about this before. I already mentioned this. You can buy property, sale. You can have, the transfers. You can have long-term leases. You can have allocation. You can have settlement, compulsory acquisition of land. All those are allotment. All those are ways of acquiring property. So guys, nothing complicated. Just the obvious things that we know. Are we together? So is there any burning question? Is there any burning question that I need to answer before we start on leases? Okay. Looks like there's none. All right. Perfect. So let's talk about leases. Very, very simple, straight to the point. Leases. What is a lease? What is a lease? Okay. So in terms of leases, what are the things that you're going to be looking at in terms of leases? The first thing is, what is a lease? The next thing is, what is a lease agreement? The next thing is, what is a certificate of lease? And what is a sublease? What is the difference between all those things? What is a lease? What is a lease agreement? Certificate of lease and a sublease. Okay. What do you get when you lease a lease? When you lease a lease, what do you get? So let us talk about this. Now, a lease is a grant. A grant. Okay. Now, a grant comes from the word to grant. Okay. A grant comes from the word to grant. Okay. What am I saying? If I grant you permission, if I grant you access, when you give someone, granting someone is giving someone something to grant. So a lease is a grant. Okay. Is a grant of what? Okay. What is this thing you're calling a lease? A lease is a grant of exclusive possession. Okay. A grant of exclusive possession over a person's property to someone. Okay. The lessor grants exclusive possession of his property to the lessee with or without consideration. Okay. So a lease is a grant of exclusive possession. So when you grant me exclusive possession over your property with or without consideration, that is a lease. So long as you are not transferring the interest to me, you are just granting me an exclusive. Okay? You are allowing me to stay on the property. By allowing me to stay on the property, you are granting me an exclusive possession or enjoyment over your property with or without conditions or consideration. Okay? Now that means that sometimes there would be payment of rent, but rent is not a feature of a lease. You could give somebody a free lease. The fact that you've allowed them to stay on your property, that is a lease in itself. So long as it is an exclusive possession. Okay? So a lease is the grant of exclusive possession over someone else's property to another person with or without condition. That is the first one. The next one is that sometimes a lease will include the document granting the lease. That is the lease agreement. Okay, so the lease agreement is the document granting the exclusive possession. That is a lease agreement. Okay, now when this exclusive possession is for a period of more than 21 years, then you have to give a certificate of lease. Okay, you have to give a certificate of lease when if this specific grant that you're giving this person or exclusive possession is for a period of more than 21 years, you have to give a certificate of lease. Okay, and then we have a sublease. Now a sublease is whereby the person having the lease also leases the property to someone else. So you are given the property by the landlord, you also lease it to somebody else. Okay, it becomes a sublease. A sublease. Are you together? It becomes a sublease. So the landlord gives you the lease for 30 years, but also you are also granting somebody else over that lease. So the moment you are leasing a lease, you are creating an underlease or a sublease. Same thing. Are you together?
Yes, mwalimu.
All right.
Yeah,
So that is a lease agreement, certificate of lease, and a sublease. So make sure you understand that. When do you get a lease agreement? You get a lease agreement when the lessor grants you an exclusive possession over their property for a specific period of time. You get a lease agreement. So the lease agreement is the one that grants the lease. Okay? It is a written, could be verbal or written. Lease agreement. Okay? And then we have a certificate of lease. If you are leasing the property for more than 21 years, then you must be given a certificate of lease or evidence. Okay? Evidence of that ownership, which is, in this case, it is what? It is a certificate of lease. And sometimes it could be a sublease. Now, a sublease means two things. The first thing, the act of leasing a lease. Umepewa, wewe pia unapeana. Okay? So ukipeana after wewe umepewa, that is a sublease. But also, ukipewa na upeane pia for more than 21 years, then that becomes also a sublease. So a sublease is both the act of subleasing and also the document granting the sublease. I don't know whether you guys are hearing or understanding what I'm trying to say, but all is fine. If you are getting lost, please, 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 mikono lazima ikuwe juu. Okay? Yes, Wakiaga.
Yeah, I'm just seeking some clarification. Is it given when the lease is 21 years or more, or when it is over 21 years?
What is the difference between what you say, 21 years or more or over 21 years? What is the difference of what you just said?
21 years or more, or over 20. When it is over 21 years, it means 21 years is not included.
No, it's so long as it is for at least 21 years. The moment
Okay,
it gets
that's
21
the clarification
years.
I needed.
All right.
Okay,
So
thank you.
21 years kuendelea. That is a question to get a title. You have to get a title for that. And the title could be a certificate of lease, or it could be a sublease. I'm very sure that some of you are still not with me on the same page, but it is okay. Ask the question. Guys, are we together?
Mwalimu, Mwalimu, this lease.
If you have a question, put your hand up. I can't see whoever is speaking. Kama uko na swali, mikono ikuwe juu. All right. That is Angela.
Yes. So I'm asking this 21 years, you give the lease the certificate of lease before or while you're creating the lease, or is it after the 21 years has elapsed, or is it just at the time of creating the lease?
When you buy a property, when do you get a title? Is it after or when you buy it?
When you buy it.
Exactly. So that's a title. A certificate of lease is a title. When you get it, you get the title. The moment you get the certificate of lease, you get the title. Okay. Another question? Okay. Okay. So, all right, let me ask questions now. So assuming that let me write it down so that I can pronounce it well. Let me use his name. Let me use his name. Or let me just explain so that I can, so that we can move. So a lease, I've said there are two things that come within a lease. Okay. The first one is the question to do with the act of granting the exclusive possession. Exclusive possession. That is a lease. Okay. And also a lease includes the document granting the lease. Okay, so you can say I have a lease on the property. You can, that is, you have a document showing the lease. And also we have said we have a certificate of lease. Okay, so all long-term leases of more than 21 years, they must be evidenced by a certificate of lease. That is why if you get a lease from the government for 99 years, the government gives you a certificate of lease. If you get a lease from the government for 50 years or 36 years, the government will give you a certificate of lease to show ownership and title. So long-term leases of more than 21 years will confer title, and that title is a certificate of lease. Are you together? A certificate of lease. So if you have a lease for 14 years, what you get is not a certificate of lease. You are only going to be getting what you're calling a lease agreement. You get a lease agreement. So anything below 21 years, a lease agreement. Anything above 21 years, a certificate of lease. Okay? Now, if you are leasing a lease, you are leasing a property that is already a lease to someone else, then that is a sublease. You are subleasing or subletting. Okay? You are subletting. Okay? And if you're subletting, that is actually you are creating a sublease. Okay? So what do you have? If you're subletting for anything from 1 to 20 years, you're still going to get a sublease agreement. Okay? A sublease agreement. If you're subletting for more than 21 years, you are going to get a sublease, which is an actual title. So a sublease is a title itself. The same way we have a certificate of lease, we also have a sublease. which is also an evidence of title. So under leases, we have the certificate of lease, which is a lease for more than 21 years and above. Also the same way, if you have a lease for 99 years and you decide to lease it to me for 30 years, you are going to give me a sublease, okay? A sublease, and that sublease is also a title. Now you have seen subleases in the context of home ownership. When people buy apartments, okay? Let me just give a small example, but I don't want to confuse you. So if I have property somewhere in Nairobi, along Wayaki Way, I build my apartment. This property is a lease, okay? This property is a lease, and I build my apartments on it, okay? I build my apartments on this specific property. Then, if I'm going to sell these units under the sublease regime, because my title is a lease, it means when I create titles for each and every, okay, for each and every unit, I am going to create a sublease. Hapo amjasikia, sidhani kama hiyo injili sidhani kama imefika. Wacha turudie. Okay, hiyo injili sidhani kama inawafikia vizuri. Let me explain it again, because I want you to understand the concept of a sublease. Okay, Jackton, I have a piece of property somewhere on Wayaki Way. Okay, when you are driving down from Kangemi all through Red Hill to Westlands, you might pass a property that I own. I'm not saying I do, I'm just saying an example. Now, if you go there, you might find an apartment there. Okay, now if I build my property and I have apartments, I can sell them in two ways. Okay, I can sell them as sectional properties, which is now the current regime, or I could also sell them as a sublease. Okay, now if the parent title, remember, if the parent title, which is the mother title where the building, you know, there's a building and then there's the land. So the building will sit on the land. Okay, the building is sitting on the land. Are you together? So in that instance, the titles that I'm going to create, are subleases. Okay, why can't they be leases? Because the mother title is already a lease, so we can't have many leases. Okay, so in sublease regime, I build my property, I divide them into 50 units. Okay, 50 units. So because I am going to be selling these leases, okay, there's only one title, which is a sublease. Okay, it is only one title that is that is a lease. Okay, so I will go to the land registry and I will create subleases for each and every unit. Okay, now the parent title will give birth to the subleases. Now these subleases, I will now sell them. Sell them to who? The people that are buying. I will sell them to people that are buying. Are you together?
We're together, Mwalimu.
All right. So you create a sublease. You create a sublease. Now the sublease, why is it a sublease? Because the mother title is a lease, and therefore, if I am leasing it for more years, it must be a sublease. I don't know whether you guys are getting what I'm saying, but let's get questions so that we can re-explain again. I thought somebody's holding their hand up. No question. All right. So guys, subleases. That is a sublease. So we have a lease, we have a sublease, we have a lease agreement. Okay, when do you get a lease agreement? You get a lease agreement if you are leasing the property for less than 21 years. You get a lease agreement. Okay, when do you get a certificate of lease? There are two instances you're getting a certificate of lease. Okay, the first instance is when you are leasing for more than 21 years, and therefore the person that is getting the lease, that is the tenant, must be given a certificate of lease as a show of title. The second way you get a certificate of lease is when you buy the lease. It means if I have a sublease, if I have a lease, a certificate of lease, and I sell it to person X will get the same certificate of lease that I had. Dhani kama tunaelewana bado, but I'll open the questions. So because I don't want us to get into leases if we don't understand this one. Once we understand this one, then everything else is going to be very simple. Questions? Whatever you've understood, try and explain it to me and see whether we are on the same page. Yes, Angela.
Okay, Mwalimu, I want to ask so the lease, maybe the title had a few number of years to expiry. So what about the subleases? How are the years allocated to the subleases?
A sublease can only be given at least 1 day, at most 1 day less than the original lease. If you have a sublease for 10 years, if you have a lease for 10 years, you can't have a sublease more than 10 years. It's a simple thing. If you have a lease for 10 years, if your lease is only for 10 years, it means when you're going to create a sublease, the sublease must expire at most 1 day before the main lease expires. So if the main lease is expiring next week, your sublease needs to expire today. So the sublease cannot outrun the main lease. Okay? Remember, the mother of the lease, the mother of the sublease is the main lease. So if the main lease is only existing for 50 years, you cannot have a sublease for more than 51 years. It must be less than the lease. I don't know whether you get what I'm saying.
Yes, it's clear.
Yes, but I will explain further. Yes, Kege?
The example that you've given on the issue of the apartments that have been constructed on land that is leased, and as the apartments are being sold, that is their sublease, the sale is by way of sublease. Now, if they are for 21 years, if the sublease is for 21 years, the purchaser will also get a certificate of lease. Will it also be called a certificate of lease, or will it be a sublease?
It is not a purchase. It is a long-term lease. Okay, it's a long-term lease. So if you have a sublease, if you have a lease as the mother title, you are going to create subleases on it so that you have a long-term lease. So what these people are going to buy is they're going to buy the subleases you've created. Or in other words, they're leasing for more than 21 years. Because nobody buys a property, an apartment for less than 21 years. They don't. Nobody does that. So the long-term leases. So they only buy the long-term leases. So the long-term leases are, now because the mother title is only one, you create subleases on the mother title. And that sublease is what you sell to them. Okay? And those subleases will exist dependent on the term remaining on the mother lease. So if the mother lease is about to expire, then when you renew the mother lease, you also renew the subleases. So the landlord will renew the mother lease, and then the landlord will now renew for the tenants the subleases. I don't know if you're getting what I'm saying. It will not make sense now, but it will. Finally, don't worry. Penina.
Oh, yes, Mwalimu. I'm just following your instructions. You have said that we give you like a scenario of what we have understood. So this is what I've captured, and I seek your guidance. So there is a lease. you acquire land from the government. So the government is the one that's supposed to give you a certificate of lease as the person who is acquiring.
Not only the government. Not only the government.
Yes.
If I have a freehold property, I can give you a lease over my property. If I have a freehold property, the land that I own forever, out of that land, I can lease it to you for as long as I want. Any person that has a freehold property can lease the property.
So it's on both, on freehold land and on leasehold land. Okay. Now, that person who you have acquired this land is supposed to give you a certificate of lease. So
if you're buying
me having that, if I'm buying it, yes.
Or
so if I
you're
get
leasing
that
for more than
certificate
21 years. Listen, if you're buying the property, if you're buying a property that is a lease, okay, you get a certificate of lease because it is a lease. If you're leasing a lease for more than 21 years, you get a sublease. If you're leasing a freehold property for more than 21 years, you get a certificate of lease. So let's start. Okay, there are two people.
Yes.
This first person has a freehold. Okay. The second person has a leasehold. Okay. Now, in the first instance, if you are leasing a freehold, for more than 21 years, you get a certificate of lease. Okay, I will give you a certificate of lease if you're leasing my property for more than 21 years. Okay, that is the first instance. The second instance is if I have a lease property, I have a lease property. If I have a lease property, then if you are leasing my lease property, then that is a sublease because it's already a lease, but you are leasing it further. So that is a sublease. If it is more than 21 years, then I give you a title document that we are calling a sublease. Okay? If it is less than 21 years, it is just a sublease agreement. Are you together? So certificate of lease, when you are leasing a freehold, certificate of lease. At the same time, when you buy a lease, let's get to the third example. Third example is I have a lease. It means the title that I have for this lease is a certificate of lease. When I sell it to you, I sell you the title. So you also get a certificate of lease. So let's go back to you. Any question?
No, there's no question. I've understood, Mwalimu. Thank you.
Okay. Penina. That was Penina. Ibrahim Bishar.
Mwalimu, mine is to understand it clear and about the leases. I have a property in Kajiado, and that property is a leasehold property for 99 years. And I have leased to someone for rearing a poultry there for 25 years. Am I subleased or that's a lease?
Do you what do you have under your bed? Under your mattress, what do you have?
Certificate.
Of what?
I have a title, certificate of lease.
You are saying two different things. What do you have? The land that you have in Kajiado, is it a lease that you got from the government or is it your own land?
I got from the government.
So if you got it from the government, what did the government give you? A certificate of lease, Sindio?
A certificate of lease, yes, for 99
so
years.
So if you have a certificate of lease, then if you're leasing it further, then whoever you're leasing it to will get a sublease. Okay?
Okay, so that 25 years, they will get it a title, a sublease. So what are the documents that they will get from the registry?
A sublease. A sublease
is a certificate of sublease?
No, it is called a sublease. Just like that, a sublease itself.
Okay. And what about Mwalimu,
It is
if someone want
title.
to...
It is a title that is called a sublease. If you look at the face of the title, it will be called a sublease.
Mwalimu, I have seen that a scenario whereby someone is given a lease of 7 years and is that someone is just insisting that he want to register from the registry. How do you go about it? I know that it's less than 21 years.
You will register. Leases are registrable. Any lease that is above 2 years is registrable. It will be registered against the title, so that if I go and search on the property, I will find there's a lease registered against the title, and it will indicate that person XYZ is the tenant. Okay, but there's no title document you're getting from the registry. Apart from just your details being entered in the register, there is nothing you're getting from the registry. But if that lease exceeds 21 years, then now you get a sublease or a certificate of lease, depending on what you're having. Are we together?
Good, Mwalimu. Thank you.
Okay, guys, questions further? I am very sure my instincts never lie. Something is still not making sense, and I don't want you. Trust me, guys, I have a lot of time. We can stay here until we get it, all of us. So don't save my time. I don't want my time to be saved. Don't keep quiet and say, oh, we need to move forward. No, we are not moving anywhere. Ask the question, do you understand when you get a lease, when you get a lease agreement, when you get a certificate of lease, and when you get a sublease? Do you? So there are 4 terms. I'm going to write them again. When do you get a lease agreement? Okay. When do you get a lease agreement? Number 2, write that down. When do you get a certificate of lease? Okay. When do you get a sublease? When do you get a sublease agreement? Let's say a sublease agreement. And when do you get, what is the last one? A certificate of lease. No, I've already written that. A certificate of lease, and then we have a sublease and a sublease agreement. When do you get those? When do you get those? Okay, so let's start with the lease agreement. When do you get a lease agreement? When you lease a freehold property, or when you lease a property for less than 21 years, you get a lease agreement. Okay, you can still register it at the land registry, but that is just for records purposes. But what you get is actually a lease agreement between you and the landlord, because it is less than 21 years. Why? The law says that you only get a title. Guys, there are only 2 types of titles in leases. When you're dealing with leases, there are only 2 types of titles. Okay, the first title is, what I'm saying is, there are only 2 things you can call a title when it comes to leases. The first one is a certificate of lease, which is a title indicating a lease for more than 21 years. Okay. The second thing you can call a title in a lease is a sublease, which is a title indicating that you have created a sublease or a lease on a lease for more than 21 years. Okay. That is all you can ever have when it comes to titles in leases. So the law says, Section 7 says that any person that leases a property for more than 21 years, they need to get a title. Now, title in leases are only 2, certificate of lease and a sublease. So when do you get a certificate of lease? We are coming there. So lease agreement is any lease that is less than 21 years. You get a lease agreement. Okay? Certificate of lease. Certificate of lease, you get a certificate of lease when you lease a property, a freehold property. Okay? So how do you lease a freehold property? The first instance is, this property belongs to me, it is freehold. I lease it to you for more than 21 years. You get a certificate of lease. Or the lease comes from the government. The government owns the land, and the government gives you a lease for how many years? For more than 21 years. You get a certificate of lease. Okay? So that is when you get a certificate of lease. Either a private citizen leasing their freehold property to you for 21 years and above, or the government giving you a lease for more than 21 years. Okay, that is a certificate of lease. Okay, now when do you get a sublease? Now a sublease comes from a lease. So if you have a certificate of lease, where do you get a certificate of lease? I, as Jackton, I can give you a certificate of lease if you leased my land, which is freehold, for 21 years. Or the government can give you a certificate of lease if the government gives you a lease for more than 21 years. So if you have a certificate of lease, there are two things you can do with that certificate of lease. The property, let's assume it is Uhuru Park, that I think everybody knows Uhuru Park. So if the property in question is Uhuru Park, that is your land, it is a lease that you have for 99 years. There are two things you can do with that land. You can sell it to someone. When you sell that land to somebody, you are transferring what you have, the title that you have, which is a certificate of lease, you are transferring to the person that is buying it. Or you can lease it to me. You can lease part of it to me. So if you lease a lease, then you are creating a sublease. So if that let's call it an underlease, so that it is clear. So when you lease a lease, you are creating an underlease. Now, if this underlease is for more than 21 years, you are getting a sublease, which is a title document. Okay? But if this underlease is less than 21 years, you are simply getting a sublease agreement. Guys, I don't know whether we are on the same page, and I'm really trying. I'm really trying. Are we together?
Yes, Mwalimu.
Yes, yes, we're
Angela,
very together.
Angela Melita. Angela, hi.
Hi, Mwalimu.
Questions for you. Number one, give me two instances where you will get a certificate of lease.
The first one is when you lease from a freehold title, you lease from someone who is holding a freehold title, you get a certificate of lease that is for more than 21 years. And also when the government gives you a lease for more than 21 years, you get a certificate of lease.
Okay, so when I buy that lease from you, from the government gave it to you and you're selling it to me, what do you give me? Let's go to somebody else. That someone else is, let me scroll down. Oh, we know Eric, yes. Eric, you have a lease from the government for 99 years. Umepewa tu leo, but you change your mind. You want to sell it to me. What are you giving me?
I will give you a certificate of lease.
A certificate of lease, because it is a certificate of lease that you are having. Okay, guys? A certificate of lease is what you are having. So when you sell land, you sell what you have. Okay? You sell what you have. And what do you have? You have a certificate of lease or you have a certificate of title. So even in terms of transfer of leases, you are simply saying you are selling your lease. So when you sell your lease, you are selling your certificate of lease. Transfer of freehold properties, you are just transferring your certificate of title. Transfer of leases, you are transferring your certificate of lease. Okay, that is transfer. Okay, that is clear. When it comes to certificate of lease, okay, when you create a lease over it, the government gave you 99 years, but you are leasing it to me for 21 years and above. You are not going to give me a certificate of lease. Why? Because you are the one having the certificate of lease, and therefore there's something called the reversion. The reversionary interest still rests with you because you are still the registered lessee. Lessor, sorry, you are still the registered lessor. Lessee. The government is the lessor, you are the lessee. So if you are leasing it also to me, then I become the sub lessee. And therefore, if it is for more than 21 years, then you're going to give me a title. But because it is a lease already, you can't give me a certificate of lease. You have to find me something else, and that something else is called a sublease. Are you together? A sublease. Now, guys, the same way, a lease can mean a title, or a lease can mean a lease agreement. The same way, a sublease can mean a sublease agreement or a sublease, which is a title. So always remember that. So a sublease is also a title that you can present to the bank and charge. Okay, you can charge a sublease because it is a title. So guys, that is that. That is that. But also remember that even in the instance where you are leasing to someone for more than 21 years, you will still have a lease agreement because it is the lease agreement that will create the lease or the sublease. So lease agreement is constant. Anytime you're doing something, you must have an agreement. That is a lease agreement. And then if that lease is for more than 21 years, you give a certificate of title. If your property, if it is the first lease, if it is the second lease, you give a sublease. Guys, enjoy, and then we can proceed to something else now.
My question is, in what instance does one need to get permission from the owner of this?
You're not asking the question. Have you eaten something today? You sound very hungry and tired. Have you eaten something? I can't even hear you. Huh?
Hear me now. Can you hear me now?
Are you sick? Are you okay?
I have a cold, yes.
Okay. Sorry. Get well soon.
Yeah.
Proceed.
My question is, in what instance does one need permission from the owner of the property or the lessor to sublease the property?
All instances, anytime you're subleasing a property, you have to get consent from the lessor.
Even if you have a certificate of lease?
If you have the certificate of lease, you're the lessor. Why do you need consent? Unless the lessor is the government. Unless the lessor is the government. Okay. But if you're creating a sublease, you need the consent of the lessor. Okay. It means if the government gives you a certificate of lease and you're leasing it to me, you need consent from the government. Okay. Every time you have to get the consent of the head lessor. The head lessor can be the government or the head lessor can be a private citizen. Okay. So all the time, the head lessor must give consent. Unless you're the head lessor. If you're the head lessor, then there's no need. So who is the head lessor? The person that holds the freehold title, which is the government or a private citizen. So anytime you're leasing, or let's say anytime you're creating a sublease, you have to get consent from the head lessor. Okay. Anytime you're selling, you have to get consent from the head lessor. But also remember that if this lease was given to you by the government, you will also get consent from the government if you are selling it. Are you together? So if you got a lease from the government, you have to get consent from the government to sell it or to lease it. So essentially what I'm simply saying is that anytime, not even just the government, even the private person, anytime any transaction you're doing on the property that you are having a lease on, you have to get the consent from the owner of the property. That is either the private citizen or the head lessor, which is the government. Because anytime. So if it is a private person that leased you the property, if you want to sell that lease, you have to get their consent. Okay, the consent of the lessor, because you're the lessee. So all the time, anything you want to do, you have to get the consent of the lessor. Tuko sawa? Okay, guys. So I hope that answers all the questions. So let us go and talk about the features of a lease. What are some of the things that will tell you that this is a lease? What are some of the behaviors you will see that will tell you that this one is a lease? Somebody else? Someone? Give me the features of a lease. All right, let's start from, guys, wekeni mikono juu bana. People that have not spoken. Gloria Kilatia.
Duration of a lease. The duration, the time that the lease will hold till it expires.
Okay. But you started very far. I want the first point. You are not wrong, but I want the first point first. Okay. Mudave Cynthia.
One of the features is that it has exclusive possession. Sorry.
Yes, it has that. Exclusive possession. Again, you started very far, but you're coming back to that. Oyeko.
There has to be a lease agreement.
Wewe. That is not a feature of a lease. Cheyech, Mariam. We can't hear you. Can't hear what you're saying. All right. She's not there. Female.
Determinate time.
That is what someone just said right now. Diana
Or
Kipsuge.
premises.
Diana Kipsuge.
It must have defined parties.
That's the first point. Parties, guys. Parties. When you discuss these things chronologically, they stick. Don't start from Mombasa and come back to Nairobi and go back. Just start from Nairobi fast as we go. So the parties. Okay? So a lease must have defined parties. Who is the lessor and the lessee? Guys, the lessor and the lessee. You need to understand who those people are. The lessor is the landlord. The lessor with an OR is the landlord with an OR. Lessor, landlord. And then we have the lessee with an E. That is the tenant with an E. Right together. Tenant, landlord. Landlord, tenant. So the lessor is the landlord. The lessee is the tenant. Right together. So every lease must have defined parties. And that is why if you are told to prepare the key clauses in that specific arrangement, you will need to have the first one as the description of parties. Okay, like I've said, always the examiner will give you an instance. And the examiner will not call you sweet names. Okay, the examiner will not call you sweet names. The examiner will just say, James is trying, James has approached Michael, and James is asking Michael to allow him use his property along Thika Road, where he intends to open up maybe a cyber business. Okay, draft 5 main clauses or 3 main clauses. Okay, in the arrangement, or I mean in the document that will be prepared between James and Michael. So the first thing you need to understand whether it is a lease or not. Okay, and then when you know it is a lease, the first thing is the description of parties. Description of parties. So the second one is Simel. What is the second one?
Time.
Come again.
Determinate time.
Where? Oyeko.
Oh,
That is not the point.
sorry.
That is not what you said before.
Sorry.
That is not what you said before. Take a sip of
Description
water
of-
and relax. Oyeko?
Description of property.
Yes. What are you listening? What are you listening? Okay, you guys, you've defined the parties now. What next? The property. So defined parties and then defined premises. Okay. Are you together? So define premises. So give a description of the property that is being leased. Okay. Now after that, Simel, what are we going to have the third?
Time.
Come again?
Time.
What is wrong with time? Why are you throwing your answers like that? What is wrong with time? Simel, I'm still on you. Answer the question.
I said determine. Okay, determinate time, something like that.
What do you mean something like that? Yes, determinable time. So time must be defined. Define time. Guys, when you are answering a question in an exam, don't just throw away. Don't just throw it like, okay, parties, property. Don't do that. The examiner will not be very happy with you. So make sure you put down your thoughts in a paragraph or in a sentence, okay? Define the parties, define premises, define time, okay? So time is determinable. So a list must have a determinable time, okay? Or at least time must be, you must be able to define the time or identify the time from looking at the arrangement. So that is a defined time. Okay, after time, Cynthia Murave, what did you say?
I'd say exclusive possession.
Yes, there must be an exclusive possession. So when you are discussing about leases, a lease is not a lease without exclusive possession. Okay, what makes it a lease, in addition to what we have already discussed, is now the aspect of exclusive possession. Okay, the tenant must be given exclusive possession. That is why if you're in your house right now and you're cooking, the landlord cannot just come and sit in your house right now and just start eating. Okay, the landlord cannot just walk into your house right now and sit down and just start eating. They can't do that. That is a breach of their duties. They can't just come at your house and do whatever they want. They have to give you exclusive possession and control. So without that exclusive control, then that is not a lease. Are we together? Without exclusive possession, that becomes not a lease. All right. Anything else somebody wants to add? Rokiaga Robert?
Would we be right to say that leases are transferable?
No. Of course they are, but that is not a feature.
Okay, thank you.
It is, yes, that you can transfer a lease, but that is not a feature. Katwa Alex?
Consideration.
No, I just explained it. I said rent is not a feature of a lease. You can give somebody a lease without them paying rent. Okay? You can have a lease with or without consideration. So rent missing or not being there is not a feature of a lease. Are you together? So consideration is not it. Are we to go sawa? All right. Angela, Melita?
Can you have the conditions for the lease?
No. You can't. Conditions will be different. These are factors that are universally accepted. They are universally accepted. Okay? So the conditions will be different. The conditions that you have with your landlord are different from the conditions that I have with my landlord, for instance. So that is different. Bishar?
Malimu, what about the statutory duties and payment to pay like rates that are there on the lease certificates?
None.
Annually.
They're not features of a lease. What you guys have already provided are the features of a lease. They're the main features of a lease that will exist in all leases. Parties, property, time, and exclusive possession. Those four are the main features of a lease. If you're told to provide Now, clauses in a lease, then you first provide the 4, and then you add. Everything else will come later. Okay? That everything else will now depend on the question. If the question is telling you that this person will be paying rent, then you'll be having a clause on rent. If this person is telling you that they've agreed on the use of the property, you'll have then a clause on the use of the property. So that will depend. And then the normal things of dispute resolution, applicable law, those are just the things that will depend on the question, and they are boilerplate clauses. But the main things are the parties, the property, the time, and the exclusive possession. Are we guys together? Those are the features of a lease. Now, let us look at the differences between, anyone with a question? I don't think so. Differences between a lease and a license. Okay, what is the difference between a lease and a license? Somebody, from what we just discussed right now, what is the difference between a lease and a license? And this question is usually set in a very funny way. How? You will be told that this is happening, or contrast the following two transactions or arrangements. The first one is somebody renting a house to use it as a business. Another one is having it as an Airbnb. Contrast. So what is the difference between a lease and a license? You need to understand that, because you'll be given instances of a license and instances of a lease. Owino Alphonse, first one.
Yes, from the discussion we've just had, the first difference will be in a lease, there is exclusive possession, while in a license, there is no exclusive possession.
Yes. You don't have exclusive possession in a license. Okay? The landlord can do whatever he wants. A license is a permission granted to you by the landlord or the owner of the property for you to do something for some specific time at his pleasure and at his mercy. So, license, they have no exclusive possession. At least there is an exclusive possession. And I will give you an example. If you are using a specific spot for parking in town, you can't go there and say, tomorrow you find somebody parking there, you can't complain. You don't have exclusive possession over that property. You only had a license to park there today. If you go back tomorrow, you'll find that place given to someone else. You don't have exclusive possession. Okay? But you can rent an entire space in town and use it as a parking space. Okay? That is different. So a lease, exclusive possession. A license, there is no exclusive possession. Okay? All right. Secondly, Omwenga.
A lease confers an interest in land, while a license does not confer an interest in land.
Okay. A lease is an interest in land. It gives you an interest. When you have a lease, it gives you an interest on the property. Okay? It gives you an interest on the property or in the property. Okay? It gives you an interest that you can claim. A lease is an interest in property that you can even transfer to somebody else. A lease is an interest. A license is not an interest. You don't have any interest in this property. You don't have any right on this property whatsoever. Okay? That is a lease and that is a license. Cynthia Mudabe.
A lease can be transferred to a third party, while a license cannot be transferred to a third party.
You can't transfer a lease. For instance, if you are given an Airbnb, Airbnbs are licenses, they're not leases. Okay? You can't start doing your things on that Airbnb. You can't start saying, oh, now let me start painting again. You come with your own bed. You come with your own things. You remove cup. You can't do that in an Airbnb. Just use it the way you find it and leave it the way you found it. Okay? Neither can you give it to someone else. Okay? If you get an Airbnb somewhere, you can't also B&B to someone else. No, you can't. Okay, so you can't transfer a license, but you can transfer a lease. You can give a lease or you can sublease it to somebody else. Omwenga?
I'm not sure about this one, but I'm just giving it a trial. A license cannot be revoked since you have an interest in that land, while a license can be revoked at any time.
Yes. A lease cannot be revoked at any time. When you have a lease is a contract and it binds every person and it gives you an interest in land. Therefore, it cannot be revoked. Okay? It cannot be revoked at any time. Okay? It cannot be revoked at any time. Okay? At the same time, when you have a license can be revoked at any time. Are you guys together? All right. Tua John.
What of you've said that a lease cannot be revoked at any time. What of in instances whereby the lessee does not abide by the conditions that have been provided by the lessor?
That is a different story now. That's a different story. If you violate the contract, then there's no stories. You go. But the lessor cannot just wake up one day and say, hey, you wake up and take your things. The landlord cannot come to your house right now and say, take your things and leave my house. They can't do that. But if you are using, for instance, a parking space as a license, you can be told to remove your vehicle there and go at any time. The license can be revoked at any time, but a lease cannot be revoked at any time. Okay? But you can terminate a lease. Okay? You can terminate it, of course. The reasons for termination, of course, one of them is breach of the covenants. Breach of the covenants. Are we together?
Yes, we are together. Thank you.
All right. Somebody else? Any question? Alingo Penina? And then we Guy Paris.
Okay, yes, Mwalimu. This is just a question. So can we say that a lease is registrable while a license is not? So
yes, but
being
not
a
all
lease
leases
that
are registrable.
Okay.
That is true, yes, but not all leases are registrable. Short-term leases are not registrable. Can I come again?
Okay. Can we specify, for example, if it is in a question?
Specify how? Can you try and specify and let's see.
I don't know. I still stand guided. Thank you.
Yes, not all leases are registrable. Some are not. You can't register some, but they're leases. The fact that you can register, registration is not a point, really, because unless you say that some leases are registrable while licenses are not registrable, could be, but really, registration does not really cut it like that because not all leases are registrable. Some leases are not registrable. Okay. There is.
Okay, I don't know whether it is right, but leases can be inherited, but licenses you cannot.
What do you mean you can inherit a lease?
Maybe when the person who holds the lease is deceased, it can pass through for inheritance.
And that is what? That is called? What did we call it in the last class?
Transmission.
Yes. So that is the question of transfers. That is the question of transfers. Okay. That is transfers. So a lease can be transferred while a license cannot be transferred. Okay. So that is the features of a lease. And of course, where do you get all those things? You get them from Desai versus Cooper and Street versus Mountford. Street versus Mountford. Those are the two cases that define the features of a lease versus those of a license. So so far we understand the key documents in terms of leases. That is the lease agreement, certificate of lease, and a sublease. And also we understand the features of a lease, and the difference between a lease and a license. Now, types of leases, the different types of leases that we have. Yes, Kamunyu.
I was about to ask a question. May I proceed?
Ask. Desai versus Cooper. Whoever is asking the question on the group, it is Desai versus Cooper. Desai. Desai is DESAI. Desai versus Cooper. Cooper is COOPER. Desai versus Cooper.
Yeah. In the features of a lease, I still feel like use of the property is quite crucial because I've seen some leases. In some leases, they've specified you cannot build any permanent structures on this land, and the minute that is defined, then I think it's quite a key feature in a lease, like the use of the property. It curtails, or rather,
No, it's not. It's not.
It's not a key feature. All right.
When you have what if it's a building? Because you can also have a lease in a building. And not all leases will have, not all lease arrangements will have a use. You can just lease a property, and the lease agreement will not tell you what to do with the property. So those are boilerplate clauses. They are boilerplate clauses. Okay, boilerplate clauses. Those are things you can agree. It narrows down, or it differs from person to person. Because person to person. So my lease with you, Kamunyu, will be very different.
I think I understand what you mean. Yeah.
You get it? Yeah. So when you talk about features of a lease, those irreducible minimums of a lease that must be there in every lease. It means if I collect all the leases that you guys have between you and your landlord, assuming that you're staying in a rental right now, if I collect all the leases of 100 of them, there are things that will be common, and those common things are the features of a will. Defines both parties, defines the property, defines the term, and also it gives exclusive possession. Everything else is just a boilerplate clause that will be depends on how well you can negotiate with your landlord. Are we together?
Yes.
Okay. Okay. Any question? No question. So now let us talk about the types of leases. Now we have very clear types of leases. The first type of a lease is a periodic lease. We have a short-term lease, and we have, of course, a long-term lease by default, and then we have a future lease. So I want us to start from a periodic lease. Okay, let us start from a periodic lease. I'm going to project my screen right now so that we can all go through what a periodic lease is. Can you see my question or my screen? Sorry. Right, so I will read so that we move faster. Now, a periodic lease. What is this thing we are calling periodic lease? What is this thing we are calling a periodic lease? Period. Periodic lease, a period. Okay. Now, this is a lease that runs from period to period. It is periodical. But let's explain. So, if in any lease, let's start there. If in any lease, the term of the lease is not specified. Okay. The term of the lease is not specified, and no provision is made for the giving of notice to terminate the tenancy, the lease shall be deemed to be a periodic lease. So the first periodic lease, or the first category of a periodic lease, is a lease whereby the term of the lease is not specified. Okay? The term of the lease is not specified in the lease agreement. It is not specified in the lease agreement. Neither is the lease agreement giving any provision for giving a notice to terminate. That lease will be deemed as a periodic lease where the term is not specified. Okay, where the term is not specified. That is the first one. The first one, guys, is that, and just like 2017 July question 5, I think it's question 5, where you're being told you're given various categories of leases, various instances. Okay, you're given various instances, and then you are told to discuss. So if you are told that this person is having a lease with this person, but the term is not specified, the term of that lease is not specified, or the lease agreement is not specifying or is not providing anything for giving of notices, then that becomes a periodic lease. That is the first example of a periodic lease. Number one. Number two, if the term of the lease is from week to week, month to month, year to year, or any other periodic basis to which rent is payable in relation to agricultural land, the periodic lease shall be for 6 months. Let me explain that again. So we have two things. The first thing is the term of the lease is from week to week, month to month, year to year. Okay, and this is determined, and this is determined with the period in which rent is payable. So if you're paying rent month to month, year to year, or quarter to quarter, or week to week, then that is a periodic lease. Okay, and if it is an agricultural land, then the periodic lease shall be for a period of 6 months. Shall be deemed to be a periodic lease for a period of 6 months. Are you together? For a period of 6 months. That is the second instance of a periodic lease. Are you together? That is the third instance. That's the second instance of a periodic lease. The first instance is there's a lease. The term is not specified. The term is not specified. Okay, that is the first one. The second one is that there's a lease. The tenant is paying rent week to week, month to month, or year to year. Then that is a periodic lease. If the term of the lease is based on the rent payment, okay, then that is a periodic lease, which is week to week, month to month, or a year to year. And then the third instance of a periodic lease is where the lessee, the tenant, remains in possession of the land with the consent of the lessor after the term of the lease has expired. Okay, then that becomes a periodic lease. Okay, so what am I saying? That if you had a 10-year lease and that 10-year lease has expired, but you're still remaining on the property, or you agreed with the landlord that I will be renting this property for 1 year or for 2 years. Okay, I will be renting this property for 1 year or for 2 years, and then I will go. And then after the end of the 2 years, you've not gone, you're still there. Then that is a periodic lease so long as the landlord has given you the permission to keep being on the property. Okay, to keep being on the property as it keeps accepting rent. Okay, then unless the lessor and the lessee have agreed expressly or by implication that the continuing possession shall be for some period of time, the lease shall be deemed to be a periodic lease. Okay, so if you are remaining on the property without any agreement as to when you are leaving, that is a periodic lease. Are you together? All right. And then the third one, the fourth one, is if the owner of the property, that is the landlord, permits the exclusive possession or occupation of the land or any part of it to any person at a rent without any agreement in writing, that occupation shall be deemed to be a periodic lease. What am I saying? If somebody allows you to stay at their place or their property, and in return you're going to pay rent, and if there's no agreement in writing, then that becomes a periodic lease. That becomes a periodic lease. Okay? And then lastly, the question of termination of a periodic lease, where it says that a periodic tenancy or a lease shall be or may be terminated by either party giving notice to the other, the length of which shall be not less than the period of the tenancy, and shall expire one day on one of the days on which rent is payable. Okay, so that is the question of termination. So let us give it a quick summary. So the first one, the term is not specified. If you see a lease that the term is not specified, the term of the lease is not specified. Okay, it is not specified. Neither is there a provision. For issuance of a notice. Then that is a periodic lease. Okay, the first one. The second one is where the lease is running from week to week, month to month, or year to year, or any other periodic payments or any other periodic periods upon which rent is payable. Then that becomes a periodic lease. The next one is once the lease has expired. If the lease has expired, but the lease has expired. Somebody's having the microphone, the video on. Melissa, Zima. So if the lease has expired, but the landlord is still permitting you to be on his property, okay? The landlord still permits you to be on the property without agreement on when you will leave, that is a periodic lease. And then lastly, if the landlord or the owner of a property permits you to stay on their property in exchange of rent without any formal agreement in writing, then that becomes a periodic lease. So when you see such arrangements, you need to know that that is a periodic lease. Guys, are we together?
Yes, we are.
All right. All right, that is perfect. So that is a periodic lease. So what is a periodic lease? All those that we have mentioned and I have listed. Okay, periodic leases. All right, so whenever you see that, you need to understand that is a periodic lease. So if this periodic lease is running week to week, you give a 1 week notice for termination. If it is running month to month, 1 month, year to year, 1 year, quarter to quarter, a quarter. Okay. The next one is a short-term lease. Okay. Now, a short-term lease is a lease that is made for a term of 2 years or less. Anything that is 2 years or below is a short-term lease. Okay, without an option of renewal. It is a short-term lease. If it is a lease for less than 2 years. So you will see a question. On leases where somebody is having a lease agreement with another for 2 years and below. That is a short-term lease. Are we together? That is a short-term lease. Number 2, all periodic leases are short-term leases. All periodic leases are short-term leases because they are running from week to week, month to month, year to year or any other periodic rent payment module. And also remember that periodic leases, the term is not specified. So if the term is not specified and you're just living there and paying rent, then that is a short-term lease also. So all periodic leases are also short-term leases. Are we together? And then a short-term lease, of course, can be made orally or in writing. And then lastly, a short-term lease is not a registrable interest in land. A short-term lease is not a registrable interest in land. Are we together? A short-term lease is not registrable. You can't register a short-term lease. Are we together? So that is short-term leases. Short-term leases. Short-term leases. Are we together? That is a short-term lease. Now, what do you need to understand after short-term leases? We have periodic leases done, short-term leases done, and then now we have something called a long-term lease. Now, a long-term lease is a lease that is more than 2 years. It's a lease that is more than 2 years. That is a long-term lease. Now, we have two categories of long-term leases. We have two categories of long-term leases. Are we together? Two categories of long-term leases. The first category of a long-term lease is a long-term lease that cannot confer title, and then we have a long-term lease that can confer title. So anything between 2 years and above, but below 21 years, is a long-term lease, but that cannot confer title. Okay, so 3 years until 20 years, 3 to 20 years, that is a long-term lease, but it can't confer title. And then secondly, we have a long-term lease that is capable of conferring title. And we said that any lease that is above 21 years can confer title. Any lease that is above 21 years is a long-term lease and it can confer title. So we have those two categories of long-term leases. Anything that is above 2 years, that is 3 years and above, is a long-term lease. And if it is below 21 years, it cannot confer title. But if it is above 21 years, there must be title. Are we together? That is clear. Are we together, guys? Is that clear? Any question on periodic leases? Okay. Any question on periodic leases? Any question on short-term leases? And any question on long-term leases? Robert?
Yes, Walimu, supposing you have a long-term lease of 3 years, which is written, and then after the expiry of, okay, you have a long-term lease of 3 years, which is in writing with no consideration. And then after the expiry of the 3 years, you continue staying there until after 12 years. Will you be able to claim adverse possession?
No, you can't. You can't, and you can, depending on the factors we discussed, the factors that are leading, the factors leading to adverse possession we discussed. Okay, and we said you must be staying there without the consent of the landlord. So if the landlord, does the landlord know you're staying there? Yes, they can see you there, yes, but did they give you permission to stay there? Is it open? Is it an open stay or you're hiding? If it is open, yes. Is it with the consent of the landlord? If the landlord gave you consent to be there, then that in itself terminates or invalidates the argument of a long-term lease. I mean, of an adverse possession. Yeah.
Thank you.
So you have to also take it through the requirements of a adverse possession. You've been staying there for long, that is 12 years, openly, uninterrupted, without the consent of the lessor, without the consent of the lessor or the owner of the property. All right, so let us go and talk about future leases. A future lease, that is very clear. A future lease is a lease that is projected to start at a future date. Okay, a future lease is a lease that is projected to kick in or start at a future at a future date. Are you together? Any lease that is supposed to start or begin at a future date, it simply means somebody is bringing up an apartment and you're telling them that ukimaliza hii apartment, nitakuja niishi hapa, nalipa rent for 5 years. I will rent your property for 5 years, ukimaliza, and you have an agreement for that. That is a future lease. It is meant to begin, or it is projected or defined to start at a future date. Okay, it's a very simple agreement. Okay, it's the same way as you are traveling and saying that once I come back, I will live here, but I will use this property. Okay, so you have an entire agreement and say this lease, the effective date, or it shall begin on, let's say, January of 2025. Or you can have an agreement and say, if this tenant leaves, I will come. There's a current tenant on the property. If he leaves, I will come and stay on the property. Okay, that in itself is a so any lease that is projected to start at a future date, that is a future lease. Okay, so when you sign the agreement will start at a date that is not the date of signing the agreement. That is a future lease. So if you look at section 6.1, it talks about a lease of land may be made for a term to begin on a future date, not later than 21 years after the date on which the lease is executed. That is the exception. So you cannot have a future lease that will start, okay, that will start in 21 years. Okay. Why? Because you know the question of long-term leases conferring title, you can't get a title for a lease that is not yet there. Okay, so the law limits it to 20 and below. So you cannot have a lease that I will rent your property in 2045. I will have a rent, or I will take a lease on your property in 2025. That is a long one. You can't have that. Okay, you can't have that. So a long-term lease, a future lease is a lease that is projected to begin at a date that is in the future. Okay, as long as that date is not later than 21 years. Okay, and then lastly, in terms of future leases, is that if the future lease is expressed to be for a period of more than 5 years, it must be registered. That lease must be registered. So what am I saying? I am saying that if you tell somebody that if this tenant leaves, I will come and rent your property, and you have an agreement for that, and you tell them, I will rent it for 5 years, then you have to register that future lease. Okay, you have to register that future lease for it to be binding. Okay, or for it to be valid, or for it to be deemed as a future lease. So that is future leases. Guys, so once more, let us go through what we have discussed. And if you have questions, please start taking notes as I summarize, so that once I'm done, you can ask as many questions as you can, just to make sure that you are not leaving here with confusions. So we have talked about the general aspect of leases and the documentation in leases. Just for purposes of understanding, we have talked about what the lease is, and we have said a lease is the act of granting exclusive possession over your property to someone else with consideration or without consideration. And also we have said a lease could also mean the document granting the lease. Okay, we have talked about what a lease agreement is, and of course it is as clear as it can. A lease agreement is just a lease agreement, okay, or an agreement that is granting the lease. Okay, we have also talked about a certificate of lease, and we have said this is a title that is given to you when you lease a property for more than 21 years. And also we have talked about a sublease, and we have said a sublease is also two things. A sublease is an element or an instance where you are leasing a property that is already a lease. You are creating a lease over a lease. That is an underlease. And if you are creating that lease for more than 21 years, then that also becomes a sublease, which is also a title document in its own, just like a certificate of lease. We have gone to the question to do with the features of a lease. And in terms of features of a lease, we have said that the first feature of a lease is defined parties. The parties must be defined. Defined properties. Defined properties. The properties must be defined. Okay, the properties must be defined. Defined properties. Defined time. The time of the lease. The term of the lease must be defined. And then the question of exclusive possession. And then every other clause will come later, including rent, everything else. Okay, we have differentiated between a lease and a license, and given the differences between leases and licenses, including the question of transferability, interest in land, revoking, and all that, and exclusive possession. We've talked about the types of leases, and we have said we have periodic leases, short-term leases, future leases, and long-term leases. Now, up to there, is there any question that we have? Leases are very simple, guys, and I will be giving us questions. Once we're done with this topic leases, we will be looking at past paper questions so that you can see how questions on leases are set. They are very simple. Leases are actually very simple. Leases are just like charges. In fact, charges are more complicated than leases. Okay, very direct to the point. You just need to understand what leasing really is and what is involved in a lease. That is all you need to understand. Are you guys together?
Yes, we are.
Yes.
Yes.
Okay. Now, up to there, guys, I'm opening the floor and I want you guys to ask questions on everything regarding leases. Anything you're not understanding, be fair to me by asking as many questions as possible so that I can feel that you've understood something. I do not want us to go forward if you guys don't understand something. So please, please, please ask as many questions as possible because it is important for you that you understand. And the only time you're going to understand is when you ask. Even if you're still not understanding the concept of this sublease thing, or you're not understanding what a sublease is, a lease agreement is, ask. This is the time. We have some few minutes, so we can ask as many questions as possible, but make sure that you don't leave this class without understanding something. So please, please, Mkono Ju, yes, Evelyn, James, we start with you.
I'm just for me, I'm requesting if you could please repeat on future leases and the other one. I lost you when you were discussing the short term. My tokens ended.
Sorry. What do you mean? What do you mean short term? We
No,
have
the short
discussed
term. The future, and the last two. I lost you when you were discussing the last two.
What is the last thing you heard me saying? Maybe I can know where to get you.
The last time I left you discussing on the short term, where you said it can be oral or written. That was the last thing I heard from you.
Wow, that is taking me back very, very far because we've discussed long-term leases, we've discussed future leases. That's like having an entire lesson all together.
Gosh. Then I can maybe listen to the recording.
That is fine, but let me just try and summarize it from where you left me. So you left me when we were discussing short-term leases, and we said short-term leases are what we said it is. So any lease that is below 2 years is a short-term lease, and we said all periodic leases are also short-term leases, and we said that short-term leases are not registrable interest in land. Okay, and then we went to long-term leases. That is where you lost us. We went to long-term leases. Now, under long-term leases, we said that number one, that there are two types of long-term leases. We have long-term leases that can confer title. So what is a long-term lease? A lease that is above 3 years, 3 years and above, or above 2 years. That is a long-term leases. Okay, a long-term leases. Are we together? That is what I want you to understand. So we have a long-term lease that can confer title, and we have a long-term lease that cannot confer title. Okay, so anything that is above 2 years, that is a long-term lease. So if it is above 21 years, between 2 to 20 years, that is a long-term lease that cannot confer title. It means when you have that long-term lease, you can't get a title, either certificate of lease or a sublease. You can't get any. But if you have a long-term lease for more than 21 years or 21 years and above, you're going to get a title. Okay, that's what we talk about. That's what we said in terms of long-term leases. And then we went to future leases, and we said when it comes to a future lease, this is a lease that is expressed to start at a future date. A lease expressed to start at a future date. What am I saying? That if you look at the lease, the terms of the lease are you will begin taking control over the property at a future date. So we are having a contract now. Are we together? We are having a contract now, but this contract will start operating in 2 years' time or next month at a future date. That is a future lease. And we have said a future lease cannot start later than 21 years. So you cannot say that I want a future lease that will start in 2045. That cannot happen. Okay? That is too long. It must be anything below 21 years. Okay, and we said that if a lease is a future lease that is expressed to be more than 5 years, you have to register it. Are you together? So that is exactly what we said, James, Evelyn. That is where you left us, and that is where you found us back. Are you together?
Yeah, thank you so much for that.
All right, somebody is really complaining on the chat there, called Samora Alosi. Today is your first class, though. You're saying 3 hours. We've not even taken 2 hours. You know that. We've not even taken 2 hours. Okay? We haven't even got into 2 hours because this class started at 8:30. Okay, and it's 10:49. So just 2 hours. It's not 3 hours. You're really crying, my friend. Calm down. Calm down, calm down. All right, but yes, I hear you. Any question? So guys, at this stage of the time, again, I understand you guys want to go do other things, you want to sleep, and so if you think you don't want, if you're okay with everything that we've said, you can drop off. But I need to take questions because they're very important as well. So I can take questions, and then once I'm done taking questions, we'll just adjourn. So if you don't want to partake in the questions, that is also fine. Okay? But we haven't taken 3 hours, though. That is too long. 3 hours will be 11:30. All right. Okay, to adjourn.
Okay, there is somewhere I did not understand. When you have a leasehold interest of below 21 years, can you sublease?
You can sublease anything, even for 2 weeks. So long as you have a lease, you can sublease it. Whether it's a lease for 1 day, you can sublet it for 2 hours. Are you together?
Yes, okay.
Anything can be sublet, so long as the sublease is not longer than the lease itself. So if you have a lease for 1 week, then you can only have a sublease for 6 days. It cannot be longer than the lease. Omwenga, and then Langat, Robert.
It's in form of a scenario.
What is in form of a scenario?
My question.
Ask.
If, for instance, I have a lease of, let's say, 99 years, and I sublease for 21 years, does it mean that after the lapse of 21 years, I will automatically get my reversionary interest?
That is the law. Yeah, that is obvious. That is not even a question, Omwenga. It's obvious. If you have, if the land is yours, let's use it this way. If you give me a laptop and you tell me use this laptop for 1 week, After 1 week, what happens? Do I just keep the laptop and keep make it mine?
I now get it. Thank you.
Yes, so that is the thing. So once the lease expires, it goes back to whoever is having the reversionary interest. So I have it for 99 years. I can give you for 90 years, I can give you for 50 years, for 30 years. So once your lease is over, it comes back to me. And then at the lapse of 99 years, it goes back to the government. So you hold the reversionary interest. So the reversionary interest is the person that is the interest that comes back to you when you have a lease. So when you give somebody a lease, it means you're not giving them forever. The one aspect of a lease is that a lease is not a transfer. So when you get a lease of a property, you're not getting it for life. It means at some point in time, it will come back. So that coming back is what we're calling a reversionary interest. So if you have a lease or if the property is yours, the land is yours, and you lease it for 50 years, after 50 years, it comes back to you. And therefore you have a reversionary interest. All right, Langat, Robert.
Yes, I wanted to know why short-term lease is not a registrable interest in land.
That is what the law says. That is what the law says. I mean, maybe it doesn't make sense it being registrable. It doesn't make sense being it being registrable, but that is what the law says. The law says you can't register a short-term lease. Maybe it doesn't make. Maybe it's too short, and therefore it doesn't make sense for it to be registered. But yeah, I'm not really sure about why, but that is what the law says in as far as that. So maybe it doesn't make sense having it registered, but you can't register it. Are you together?
So at which period we can register a lease?
Wewe nakutumia watu hapo wakupige vibaya sana wakusalimie. What is a short-term lease? We have said short-term leases are not registrable. So what is a short-term lease? Answer. Ama unitumie location, nitume watu hapo wakusalimie.
For 2 years or less.
So 2 years or less. So if 2 years or less is a short-term lease, and we have said short-term leases are not registrable, it means what lease can you register? From?
More than 2 years.
Perfect. That is exactly the answer is. So you're lucky. You will not be greeted today. So that's what we're saying, Robert. We are saying that if you have a lease that is 2 years and below, that is too short, and therefore you can't register it. Okay, you can't register it. But anything after that, that is a long-term lease. Okay, that is a long-term lease. Are you together? That is a long-term lease. So anything that is above 2 years is a long-term lease, and therefore you can register it. But anything that is below that, Robert, you can't register that. That is a short-term lease. Okay, so that is what you need to understand. Short-term lease, 2 years below. The opposite of that is long-term, and we have said long-term are twice. There's long-term that can confer title, that is after 2 years up to 20 years, that cannot confer title, and then 21 years and above can confer title. Tuko sawa?
What about sublease and handle lease?
Same concept.
Okay, thank you.
So a sublease that is less than 2 years, you can't register. But a sublease that is above 2 years, you can register. The same way, a sublease that is more than 21 years can confer title. But a sublease that is less than 21 years cannot confer title. Tuko sawa? A sublease and a lease. A sublease and a lease are just the same thing. They're the same thing. The only difference is that a sublease is now created on a lease, but it's the same concept, same principle, same everything. Okay? That is what you're saying. So we have periodic subleases as well as short-term subleases or future subleases. The same concept, guys. It's the same concept. It's the same thing, because a lease is a lease, whether it's a sublease or a main lease, it is a lease. Tuko sawa? I hope I've answered that question, Robert Langat.
Yes.
All right. So guys, I will advise you this. I will tell you this as we close so that you guys don't complain. Leases you will not understand today. You won't understand them right now. Okay? But you will understand tomorrow. If you go and read after this class, you'll understand it. So don't beat yourself. If something is not making sense now, don't worry. Allow yourself to not know for now. So go and read, and then when you come back to the next class, as we get through the remaining aspects and control tenancies, we will go through this again. We look at some past exam questions, and you will see whether you understand. But trust me, you will understand. For now, it might seem like it's not making sense, but it will make sense. Don't kill yourself. Don't beat yourself up. Just allow yourself not to understand it now, but do something around it. Read something about it. Ask questions around it. Do everything that you can. Even going to YouTube and watching a video on leases. That YouTube has everything. Just watch a video on leases. If it's not making sense, maybe you could get a video there that can explain it to you better. What I'm saying is do anything that you can do. But if you still feel like you don't understand the concept of subleases, all that, do not worry. If you can, ask all the questions you can, even to me personally. You can drop me a question. If you have a question, I will explain. But make sure that you understand. Tuko sawa? Other than that, please take care of yourself. Read. Everything else shall be okay. Okay, so that is the end of the class. Unless there's a burning question, I will want us to adjourn there so that I can give you time, guys, to go and do your things. But we shall resume tomorrow with civil. We start with that past paper question that I said yesterday. But unless apart from that, if there's any question, ask. But if there's no question, please go back into your notes. Leases, the only thing you need to understand is understand the concept, really. For now, there's nothing periodical here, or not periodical, I mean, but procedural. Just understand the concept. What is a lease? License, lease, yes. Features, how can I draft a lease? What is required in a lease? Same things I've already discussed, okay? Duties and covenants, we'll discuss that. But for now, understand until the types, and then the rest of the things will follow. Please, take your time, go through them. When we come back, I will circle back again and explain the things I've already explained, and then we can see. If you get time, ask the questions. You can always ask anytime. So long as I'm still breathing, I will answer that question. All right, guys, take care of yourself, be good, and the recording will be stopped right now. I will share the recording. Ask for this recording right now. Of course, you know the rules, you know how it works.